Hi, welcome to my channel. Please like, comment, and subscribe. Once you sail out of Houston and leave the national boundaries of the United States, even if you are a U.S. citizen employed by a U.S.-based company on a ship registered in the U.S., some laws designed for your protection no longer apply. Fortunately, other laws move into play that restore some of this protection, but in a different manner. One such law is the Merchant Marine Act. It is an expansive law that includes regulations governing maritime commerce in U.S. waters between U.S. ports. Section 27 of the Merchant Marine Act, also known as the Jones Act, required that commerce between U.S. ports be transported only by American-built vessels. The Merchant Marine Act and the Jones Act are often used synonymously, but in actuality, the Jones Act is a part of the Merchant Marine Act. The Jones Act also includes provisions that have seafaring workers' rights at their core. These provisions include the owner of the vessel must use reasonable care to maintain it for safety and seaworthiness. The owner can be found liable if it is found negligent and the negligence led to an injury. Qualifying sailors, officially classified as seamen, who has suffered injuries or illness while at sea can recover appropriate compensation from their employers by lawsuit if necessary. The notion of a vessel's seaworthiness is extremely important, as it can move a case from one where the best outcome would be the recovery of basic expenses, called maintenance and cure, to one where all of the victim's losses are recoverable. The major provisions of the Jones Act apply to a special class of worker called a seaman. It is a legal recognition and very important to the process when injury claims are filed. But there is no binding definition of a seaman anymore in the Jones Act or the Merchant Marine Act. There is precedent, however, and maritime attorneys for both sides have to sort through past cases to determine if the plaintiff qualifies as a seaman. Simply being employed by one of Houston's many shipping companies and spending time out at sea working that job is not enough to qualify as seaman. In lieu of a legal definition, most maritime lawyers and judges typically agree on the following definition. But the definition has undergone a metamorphosis of terminology over the years, and it's still subject to revision. Seaman means an individual, except scientific personnel and sailing school instructor or sailing school students, engaged or employed in any capacity on board a vessel. That is nice and tidy and a refined and more cumbersome definition that preceded it, but the Jones Act has progressed back a bit, insisting that the qualified seaman worker must spend at least 30% of his or her time on board or out of sea. It is a point upon which the opposing side in an admiralty case can agree for hours. With an overarching definition to go by, however, it often becomes a stumbling block to the process. Workers who do not satisfy the term for the definition of a seaman can still recover damages from the Longshore and Harbor Workers' Compensation Act. This federal law allows the injured party to recover losses for medical expenses, lost wages, rehab, and etc. due to an injury, as well as survivor benefits in the injury causes the worker's death. These cover dock workers, shipbuilders, and harbor construction workers who were injured in the wharf area of the harbor. The provision of the LWHCA differ from standard workmen's company laws on and generally provide for slightly better compensation. Without the safety net of workman's comp, maritime employees often have to rely on the provision on the Jones Act for compensation. In a few ways, maritime workers actually have a better system at their disposal, which is why contacting a maritime injury lawyer is of utmost importance when an injury has occurred. With the provision of the Jones Act to rely upon, maritime workers can file negligence lawsuits that go beyond standard maintenance and cure for certain types of injuries. They can receive a more substantial settlement when they file a negligence suit and only have to prove that the employer's negligence merely contributed to the injury in some way. In other words, the negligence doesn't have to be the entire reason for the injury. It can actually play a very small role to be relevant. Employers can contend that maritime workers must acknowledge the substantial inherent risk of working aboard a sea-going vessel, but it doesn't absolve the employer of ship owner or liability when something goes wrong. Employers are expected to build and maintain the ship to code, make repairs as needed, and provide a safe work environment. Reasonable care must be exercised, and they must foresee potential for mishaps and then take steps to eliminate them. Negligence is not limited to the way the ship is maintained. Sometimes decisions that put workers at unreasonable risk must be held to accountability, requiring workers to perform tasks in unsafe sea conditions, forego safety procedures, perform tasks for which they have not been trained, or to stray from accepted practices regarding sea-going cargo are just a few examples of conduct that can be considered negligent. Maritime workers face situations and endure conditions that would send more landlubbers into a state of fear and despair, while for the most part they understand the hazard they are exposed to and have various ways of coping with them and minimizing the risk accidents do happen. Among the most common injury-producing accidents suffered by maritime workers are slip and falls, solidly number one in injury claims. In wet conditions, slips are common and occur on stairwells, on docks, or even in crew areas. Bump and collisions, swinging booms, cranes, dollies, cart machines, and unsecured cargo can bash into workers. Lifting and carrying mishaps, a tilting deck and rolling seats can make lifting heavy objects treacherous. Even under ideal conditions, heavy lifting is risky and poor. Illness. Not every claim is due to an injury. Sometimes crew members become ill due to unsanitary conditions and improper food preparation. When the ship is out to sea, an injured worker's only medical option is the onboard medical staff, also known as the infirmary or sick bay. This can be a real asset or pose a real risk if the personnel are inadequately trained. In extreme cases, a transport helicopter may be needed, but weather and sea conditions can play a role in whether a helicopter can be dispatched. Right, thank you so much for watching. Don't forget to like, comment, and also subscribe.